Katie. All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good afternoon, Council. My name is Vicki Henry. I'll be your panel chief today. My pronouns are she, her, and judge. I'm joined today by Justice Shin on my right and Justice Brennan on my left. We're here for one case this afternoon, which is 2024 P 728, Department of Children and Families and another versus Mother and another. This case was carried over from last week. So, Council, I apologize in that I had no idea, and I would encourage Attorney Schoenevert, I didn't know you did not live here, so we're very friendly. I wish you would speak up if this ever happens again. And I'm happy to say it's a very rare to never occurrence that an attorney fails to appear. So with that said, we'll hear argument in the case, 15 minutes per side, no rebuttal. We are quite familiar with your materials, so if you've made the points you want to make, then you can finish early, but it's your 15 minutes, and we look forward to your argument. So with that, I think we're starting actually with Attorney Schoenevert.
Yes, good morning, Your Honors, and thank you, Judge Henry. It's hard to know what to say in a situation like that. I didn't want to seem whiny, and I was going to be. I'm going to be in the Commonwealth later on this week, so I was hoping that the stars would align. But at any rate, may it please the court, I'm here. I represent Mother in this matter. My name is Dana Schoenevert, and this appeal is not about necessarily disrupting the trial court's finding of unfitness, but it's about the erroneous finding that DCF made reasonable efforts towards reunification given Mother's disability. But the threshold issue is whether this court can even hear the issue of reasonable effort for the first time on appeal. And while DCF argues that the issue must be raised at trial, there is precedent that confirms that appellate court can review reasonable efforts claims for the first time on appeal when the issue is central to the case. And we would argue that issue certainly was central to the case. Mother's disability and its manifestations were central to the case and had been apparent for nearly 2 decades because Mother was in custody. She was a DCF consumer herself as a child. She's got a well-documented history of the manifestations of her mental illness. And for years, DCF knew this, or at least were on notice that this was the case, and failed to make accommodations, right? So, the reasonable efforts argument should be able to be, at least be able to be considered on appeal, just given that it has been a theme for the very long time that Mother had been involved with the Department of Children and Families.
So, Counsel, I understand that it's been a theme with the department, but was there any hint of it at trial? Yeah,
the record is there's overwhelming support that the DCF social workers testified to, how visits went. Like I said, the very disturbing manifestations of her mental illness. The record is replete with examples of that, and the record the record appendix, not only the testimony at trial, but but DCF's observations of Mother during her involvement with them. So yes, there's ample testimony and ample documentary evidence that supports that she did have a disability. As a matter of fact, the Department of Children and Families conferred with their mental health specialist, who recommended prior to the removal of the first child that if they were going to remove that child, then they would need to convene in a so-called ADA meeting prior to that removal, so that they could really assess Mother, right? Evaluate her to get an idea of what her needs were, what her diagnoses were, and what her needs were, and how they could serve her. And the department never convened that meeting. What
accommodation is mother saying should have been given to her?
Well, there are a number of opportunities that several accommodations that she could have been given during this time. They essentially, the first one, they essentially gave her the telephone numbers, the contact information for the children's care providers, and told her that she could follow up with them and get information for the kids on her own. Well, the record supports that she would not be able to do that on her own. So more hands-on support that she could access to be able to get to the children's or participate, meaning, or at least be invited to the children's appointment, participate meaningfully in those appointments, and learn about them developmentally, especially as it pertains to the child that was diagnosed with autism. There was a service that they could have referred her to so that she could have learned more about, or she could have been educated about autism and what it was. The record reflects that she had no understanding of what autism meant. She thought that it meant that her child was stupid. She had no clear understanding of the clinical implications of, what that condition meant. And DCF withheld that education from her because of her temperament. But had she been provided, perhaps referred to the service that could have educated her on the condition, she may have embraced it and may have been able to be a more effective parent at visits.
So I'm sure you know that the department's argument is that they attempted to provide resources, but the mother refused to work within what they had attempted to provide, that she was not cooperative. What's your response to that, to their position that they really tried, but they just couldn't work with her based on her own deficits?
My response to that is it is their responsibility under their own disability policy 23-04 that requires them to find a way to work with parents with disabilities. They cannot use her temperament as an excuse not to meet that statutory obligation. That would be my response. It was their responsibility to find a way. And for decades, they were not able to do that, and to mother's detriment. When there's evidence on the record that she was able, with support, to care for at least the older child who she had in her custody for just a little bit when he was born. Her deficits were apparent at the time of his birth, yet she was allowed to maintain custody of him with the support of the paternal family. And she was able to do that until there were allegations that arose that did not pertain to her mental health. And it was at that point where, it just sort of fell apart for her. While the child was in her care for that short period of time, she was able to meet his needs, provide the minimally acceptable, at least the minimally acceptable level of care for him. And it was until those new allegations were lodged that the DCF held this meeting with their mental health specialist. They said the issue that arose was primarily due to domestic violence and not her mental health. But the department removed the child anyway, and then she began to, become dysregulated and not be as effective as she was at the beginning. And it's not really, the argument here, Your Honors, is not that DCF did not provide services, right? They did. They did provide some services. But the argument is that they did not tailor those services to accommodate her disability, which was evident for the entire time that she was involved with the department. And it is their obligation to do that. And they failed to do that, which makes the lower court's finding of reasonable efforts by the department erroneous. That is the argument.
So the child argues that adoption of Gregory held that the ADA may not be used as a defense in a termination of parental rights proceedings. What do you say to that?
Well, I'd say that I would just rely on what I said at the top of the argument, which is that we're not looking necessarily to disturb, for the court to find that mother was not currently unfit. I think that we have to concede that at the time of trial, she was not ready. Arguably, however, we do believe that had DCF leaned in and complied with their own disability policy, the outcome could have been very different for mother and the children, which leads me to my third point that I wanted to address with your honors, is the lower court's finding that there was no bond between mother and the children such that there should be no post-termination or post-adoption visitation. The DCF's position of the court found that, because the children did not seek comfort from mother and her behavior was disruptive during visits, that this translates to a lack of bond. But interestingly, mother attended these visits for 3 years, initially at 4 times a week, and then they were reduced in frequency later on, or as the case progressed later on in the case. But interestingly, the judge found that due to the amount of time that the children were with their respective caretakers, they were able to develop a bond with them. Even the older child who was autistic was able to demonstrate that he was bonding with the foster parent. And it would seem to me that the length of time that mother was attending these visits with the children, the DCF allowed these visits to go on, but there was an implication, there's a reasonable inference that the court declined to make that these visits were beneficial for the children, despite mother's sometimes unparental-like behavior, and that it was disruptive for the child, especially for the child with autism, because such disturbances in visiting or having access to mother as the biological parent, the primary parent for the first time of this child's life, would be disruptive because he is neurodivergent. So the record does support that mother had her fair share of challenges with the department, but it doesn't show harm, and that's another point, is that there must be a showing. It seems like there must be a showing of actual harm that the children would incur, or that would be imposed on the children by continuing visits with her, and that harm is not clear on the record. So we would ask.
You would argue that the judge erred in ratifying the department's drastic reduction of frequency of visitation from 200 plus visits a year down to 12, but that was all prior to trial, right?
That was during the pendency of the proceeding, yes.
Right, so there's nothing we can do about that, right? I mean, is that moot?
Well, I mean, there's not nothing. I wouldn't say there's nothing that the court can do. I think, by the finding at the end of trial was that visitation was not in these children's best interest, that there would be none. And so mother would ask that there be a remand to consider that, given the disabilities of the older child and the benefit that he would reap, at least him, would reap by having continued contact with her. And then also that, there is evidence of bonding on the record, and we would ask that the court be able to reconsider that. So if there are no further questions from your honors, I would rest on my brief.
All right, thank you very much.
Thank you.
May it please the court, Jeremy Bayless for the Department of Children and Families. I think it's important to start with looking at what actually must be preserved in order to raise reasonable efforts on appeal, because the language is not that the department must be aware that a parent has a deficiency or a need. It's rather that the inadequacy of the department's services must be an issue that is raised before trial. And that is the case because in order to evaluate whether the department is making reasonable efforts, A court needs to have some form of record as to what is available, what the parent might actually participate in. There needs to be actual evidence in the record of what the alternative was. As of right now, Mother asked this court to speculate whether or not there was in existence some program to educate Mother about autism that she would have participated in that could have helped. And that's not in this record, and that's something that needs to be tested before the trial court.
Breaking that down, there must be a program about autism, given the prevalence. I mean,
Sure.
okay. So the issue really is whether she might have benefited. Is that the issue?
Whether she would have been willing to do it. She denied her own disability. She vehemently and at
Right,
times-
but backing up, so you said there has to be some, the inadequacy of DCF's efforts must be raised before trial, but it seems like DCF's own staff was raising a concern, because your own staff was saying we need to have an ADA meeting.
Yeah, I think there's also something of a confusion about the purpose of the ADA meeting. The ADA meetings are for consumers with disabilities to present and request an accommodation, to evaluate whether there's any accommodations that can be provided to address their limitations. That is sort of parallel to the department's ongoing efforts to evaluate its service provision, whether its action plans, what it's doing is appropriate. That's done during the foster care reviews. And so what we had here was, it was recommended internally that we do an ADA meeting. Mother denied she had a disability. Obviously it was observable that there was one, but Mother denying it is relevant to the ADA. If this was an employment case, we would not be able to just do that on our own. But at the same time, we also had regular ongoing meetings through the foster care reviews that were supposed to be evaluating, among other things, whether the department was successfully providing appropriate service. And Mother was refusing to attend those. There were 4 that happened, Mother attended 1. So we're in a position where the department's disability plan, and that's in the addendum, 72 talks about what is supposed to be done when the department observes something that would make it believe there's a disability in play. One of the ways to address that is through an ADA meeting. I'd argue that is if the parent is wanting that. The other options are internal consults with both our staff, supervisors, experts, and the like, as to how to proceed. But how to implement that is going to be happening through the various other aspects of department case management that Mother was refusing to participate in. Mother was rejecting any suggestion that she was parenting wrong, I think is how she viewed it, but that there was a deficiency in her parenting style. At visits, when she was asked to bring appropriate food for the children, she refused. She brought inappropriate adult food. She brought the wrong formula for the child that was formula feeding. She was not willing to engage with the department's efforts to try and guide her towards a better understanding of her children's needs. It wasn't just that she thought that autism made her child stupid, it's that she rejected that he had autism at all. And she wanted him to be smart like his infant brother. She didn't understand the development needs, even of an appropriately developing child of that age, a child who doesn't have any medical condition. She was trying to make him sit down and do math problems so that he wouldn't be stupid, that he would be smart by, again, his infant brother. Any evaluation of whether or not a service would have worked needed to happen in the context of whether Mother was willing to even believe it was necessary and participate in it. And the time to do that was at a time when an order could have at least given her the chance to do so.
So I take it your position is that even if DCF's records say we need to have this ADA meeting and then DCF didn't, we can still affirm?
Yes. Yes. Even if the department, going a step further, even if the department had failed to make reasonable efforts, Walt and Rashida, there's a long line of case law that say that the court has to act in the child's best interest. And that sort of gets to the second part. Even if it were properly considered by this court, even if we were to look back and say that, oh, there's this service that should have been provided that wasn't, and it was purely the department's fault, unquestionably that we didn't make reasonable efforts, we're still left with a parent who refused to engage in any services that were provided with her, a parent who did not understand her children's needs, who was not interested in learning about them, who was overtly hostile to the department, and who was overtly hostile, demeaning, and abusive to the children during visits. that the judge did not err in finding that termination was in her best interest, because there had been, as my sister points out, decades of parental failings with supports in place where she was the one not engaging him. She was the one not reaching out to the service providers. She was the one behaving threateningly towards both service providers that did get in place and department staff, and she was the one who was being hostile to her children. So even if this had been the department's failing, we're still left with an evaluation of mother and whether or not she was unfit to the point where termination is in the children's best interest, and this record establishes that clearly.
So she maintains that she kept a regular visitation schedule of 4 times a week from June 2020 to May 2023. Is that accurate?
Her visitation was tapered off. She was initially given 4 days a week to accommodate breastfeeding, and then as she began to display more concerning behaviors, those were reduced. I apologize, these specific reductions I don't have off the top of my head, but she wasn't at 4 days a week at the time of trial.
Do we have to address her argument that the judge's reduction of visits from 200 plus to 12 a year was an abuse of discretion?
No, that should have been raised before trial, and it should have been raised when it happened. What is on appeal here, what is appropriately before you, is whether or not the lack of a visitation order, and just to clarify, it's not an order that there be no visits, it is the lack of an order of visits. There's nothing precluding if the children start asking an arrangement later by the pre-adoptive family. So
is there an order that the children may visit each other or should be brought to visit each other?
I don't recall. The children were not seeking an order of visits for each other. I'd argue that that's the appropriate party for preserving that right. But also, as adoption of Garrett lays out, and also in the statute, visitation can be left to either the court or the department. And so it's not error to fail to make an affirmative sibling visitation order. And if there is a problem with that, the children have appointed counsel through their adoption, and they have the ability to raise that issue if that's the children's rights, not the mother's. The same with any post-adoption visitation with mother is a right that lies with the children, not with mother. And while the record might have reflected fondness and attachment from mother towards the children, she is incorrect that the court erred in finding that there was no bond from the children to mother, such that the abrupt severance of their relationship would not be in the children's best interest. To the contrary, there is ample evidence laid out in detail in my brief that mother was hostile, demeaning, and abusive to the children at visits. You know, she held the infant, but she held the infant because she ripped the child out of the social worker's arms. You know, she brought a cake to the older child's birthday, but didn't give it to him or wish him happy birthday because she got so mad that the department asked her who dropped her off that she sat in a room and cried for 45 minutes and left without wishing the child a happy birthday. The visits did not go well. They were overtly harmful, and that's was a large part of the judge's decision. There was no evidence in this record that there is a bond that rises to the level of justifying a visitation order. It's not that there must be a finding that visits are harmful. It's to the contrary. There needs to be affirmative evidence that visits are necessary to protect the children from harm. And so there was no error in the lack of a visitation order. And if there are no other questions, I will rest on my papers.
Thank you very much. Well argued by both sides, and the case is submitted. Oh, and the child is submitting on the brief. Thank you to our court staff for your help in setting up this extra argument.